Welcome back to Real Estate 101. I'm your host, Joe Terceira, and today we're going to continue our discussion on family law, and I'm pleased to be joined by Todd Slonim of Devry Smith Frank LLP. Todd, welcome to the show.
Thank you very much.
So Todd, I want to start today's topic and talk a little bit about family law. It seems that, most people or some people find out about their divorce after being served with court papers. Do you have to go to court after being separated?
Not at the first instance. Court is one option, and eventually, if you are going to be pursuing a divorce, there may be a necessity to provide documents, or there will be a need to provide documents to the court. But normally, what will happen is often spouses may have a discussion first about their separation, if it's amicable, look at their options, and then speak individually to lawyers. Or, alternatively, one of the spouses may speak with a lawyer first, get some of their understanding of their rights, and the lawyer will effectively write a letter, an engagement letter, and that letter will be sent to the other spouse and ask that spouse to seek out a lawyer and to have negotiations start between the lawyers.
So the process begins.
And then the process begins, exactly.
All right, so can two spouses draft up an agreement themselves, and will it hold up?
You're talking about sort of a kitchen table agreement, and often parties will speak about the issues that are affecting the breakdown of their marriage, and they may work on terms that they think are reasonable. The problem with that way of producing an agreement is, of course, they don't understand their rights under the law.
Right.
So preferably what you would like to see is they may have an idea of what they would, how they would like division of property, support issues, things of that nature. They would bring those ideas to a lawyer, and the lawyers would go through the various terms and then really develop and expand upon those issues.
So what are the rules that spouses have to follow in order for an agreement to be enforceable?
So an agreement must be in writing. It must be signed by both parties, and it must be witnessed. Outside of that, outside of those formal conditions, you need to have full financial disclosure from both spouses. That means that each spouse must understand the liabilities and assets of each party, so that they know that there's truth and honesty in the agreement. Both parties must understand the nature and the consequences of the agreement. And the contract must not violate the law of contract. So, for instance, someone can't take advantage of another party. And if those conditions are met, the agreement should withstand attack. Although, in family law, a lot of things can happen, of course.
Right. Yeah. Okay, so if a separated couple can't work out their issues on their own, what are their options?
One of their options is to seek out a family law lawyer like myself to help them understand their rights, responsibilities under the law, and to help them facilitate a negotiated resolution, hopefully in a positive way.
Right.
The lawyers generally want to work with the parties to help them resolve all the issues in a way that is amicable and civil. If parties cannot work out their issues through lawyers, there are other means that can be pursued. This is called the alternative dispute resolution method, and there are various ways of pursuing that. There's mediation, arbitration, as well as collaborative practice. The first one, mediation, is where a third party is brought in to help mediate a settlement. So where parties are stuck and they need some additional direction, they would use the third-party mediator to help bring clarity into the situation. The mediator is a neutral person who helps think outside of the box, so brings a different, clear perspective, exactly. And he's not tainted by, let's say, the lawyer's bend towards protecting their clients. So it brings confidence to the process.
So I guess in a sense, a mediator is kind of trying to protect both parties, or making it fair for both parties.
Well, in a sense, although anything that the mediator does is not binding.
Right.
So he is trying to facilitate a resolution in a way that is hopefully, well, really is overall fair to both parties. But fair is a very liberal term.
Right.
But you know, mediation is an expedited, can be an expedited process. Although both parties generally pay for the mediator, they can get in front of a mediator usually quite quickly. A mediator tends to be a family law professional, a family law lawyer like myself, or a mental health professional, such as a child mental health professional. And these are individuals, obviously, who have an understanding of the various dynamics that are involved in family law.
All right. So why would two parties want to pay for a mediator? I mean, couldn't their lawyer just negotiate, you know, the agreement themselves?
Sometimes during negotiations, things tend to get heated, and a lawyer's duty and responsibility is to his client. And often lawyers find that there is misinterpretations or interpretation issues on certain points that they can't resolve. And so rather than running to court, which tends to be quite adversarial, they seek out a party who both parties agree to, because this is a process that both parties have to agree. They sign an agreement, a mediation agreement, and they are joining that process in good faith.
All right.
In an attempt to resolve their issues. And so a fresh perspective sometimes is very helpful to both parties. Both parties can gain trust in a third party, understanding that he or she is a neutral party.
Okay, so if mediation doesn't work, then what?
Well, if mediation doesn't work, then you can go to another step, and that can be either arbitration or mediation arbitration. Arbitration, again, is a process that you have a third party, usually a senior family law lawyer, that helps determine particular points where there is no consensus. So you're asking this third party to make a decision that is binding. The arbitrator has the same powers as a family court judge of the Ontario Superior Court.
Right.
So as I said, his findings will be binding, and he's helping to find the truth on some point. And it can be an expedited process again, because those parties are agreeing to the process, they agree to the type of process, they can streamline it so it's not as adversarial, and they can allow that process to take hold and then resolve the issues through the arbitrator. Alternatively, you have a process called mediation arbitration, where the mediator also acts as arbitrator. So he sort of shifts hats.
Right.
So he tries in the first part as to settle issues as his role as a mediator. If he's unable to settle the role as a mediator, then he puts on his arbitrator's hat and then delivers a binding decision based on the process that the parties agree to.
Oh.
So it helps in terms of being more expeditious, cost-effective, less adversarial.
All right, Todd, so it sounds like paying an arbitrator could be expensive. Now, why would two spouses choose to do that?
Well, we have to look at the alternative. Court can be very expensive. The reason for that is there's a lot of safeguards and procedures that are built in to the court process, which means it can take a very long time to get through those procedures. Often trials can take an exorbitant amount of time and occur after months or years. And so the whole process is designed in court to protect parties, because one party can effectively take the other party to court without their permission, whereas in the arbitration process, both parties are agreeing to the process.
Have to agree to it, yeah.
So they design the process, and the more streamlined the process is, the quicker, more expedited the process becomes. The cost up front might be more expensive in terms of the cost of paying the lawyers and the arbitrators, but overall, it's an expedited process, and therefore you actually are saving money generally.
So for today's final question, I've also heard about another method called collaborative practice. What is that?
So collaborative practice, excuse me, is a negotiation style. It's basically where the parties agree with their lawyers to work together in a collaborative way. The traditional roles as an advocate, in terms of the lawyer's role, is not followed. They act more as a facilitator. So they help each party recognize each other's party's positions and work with them to design a resolution that is acceptable to both parties. If the parties don't agree to the process or want to pull out of the process, then anything that is said or anything produced during the collaborative practice cannot be used at court. So it's a disincentive to jump forums, to start off in a collaborative way and then go to court. Right. It can be very expensive. Collaborative practice works where parties want to work together, work in a collaborative way. If one party is trying to take advantage of the other party, or there are abuse issues or power issues, collaborative practice is probably not the best, and a court may be the better option. If both parties want to work together, again, collaborative or the other mediation, arbitration are also valid options.
Alternative.
Yes.
All right, Todd, thanks very much for coming on today's show.
Well, thank you very much.
If anybody has any more questions or would like the help of a top family lawyer, they can get in contact with Todd Slonim at Devry Smith Frank LLP. I'm your host, Joe Terceira. Thanks for watching, and we'll see you next time.